Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, this is Charles, Dan and Rebecca, and we're excited to talk to you today about modifications of custody and visitation, especially as we come to the end of a summer vacation or any sort of school break where the kids have been out of school. You've really gotten an opportunity to test out co-parenting with the other parent, and maybe at this particular point in time, you see that things aren't quite going as you thought they should go. So, Dan, I want to start with you today and ask, what do you advise clients who are coming off of a vacation and they contact you and they're like, this just isn't?
Well, I advise them, what documentation do you have? Is there anything in writing? Do you have any emails? Do you have any text messages, any voicemails? Something that we can at least look to determine, does it rise to a level of a modification? And I get it. Clients are frustrated when they come in and they're either disappointed, they're upset, you name it. But also, our job sometimes is to be the bearer of bad news, in the sense that I get what they're going through. I'd be the same way too if I was denied time or my time was short with my kids. But sometimes those frustrations don't rise to the level to modify or to even have judicial intervention. And in my experience in the states where I'm licensed in, there's a threshold. And in order to meet that threshold, you have to show substantial continuing change. And a lot of times clients think, well, just one time is that change. That's the harm. Yes, it is the harm in the sense that the child was the victim because they didn't get to spend the quality time with that parent. But in the court's view, at least in my experience, it has to be continuing, meaning not just one denial or even sometimes two denials. There has to be that continuing change or that continuing issue happening. And the way that I address it with the clients is, let's send a letter to the other side. Let's identify what the issue is, what your concern is, and ask for compensatory time, or how can we make this up? And hopefully that will resolve it. Usually getting an attorney involved and sending that letter 9 out of 10 times will resolve the issue. If it doesn't, then you still just have to continue to document, because by the time that we get into court, I want to be able to show the judge, we try to resolve this without judicial intervention. These are steps that we tried taking. Either the other parent denied, didn't respond, or didn't even comply. So now we need your help. That, in my experience, goes a long way, as opposed to you miss a day or two, you go in the court, and the judge is upset because you're taking up the docket when it was just a day or two, in the court's mind. Not saying that was right, but your best case in that situation would maybe just a slap on the wrist to the other side. And you're spending all this time and all this money, and for no relief. The court may not even order compensatory time. So I always want to make sure the clients understand that I get what you want, but we have to manage their expectations. And that's the toughest part of our job, is really managing and level setting with the client, because they come in and they want to file, and we have to say, listen, this just really isn't the right time to file, but here's the steps that we need to take to position you in order to potentially file if something else would happen.
And Rebecca, Dan brought up something that I think as a practitioner, and even all co-parents have to deal with constantly, is that the other side just does a million little cuts, right? It's nothing big. We never get to that big thing where the other side decided to fly the children from here to a non-Hague country so you can't get them back. Like those big things rarely, they do happen, but they rarely happen. So how do you talk to a client who's just come off summer break or some other extended school visitation, and they're like, look, every single day I couldn't talk to my child. I couldn't talk to my child. It was this, it was that. And then they would call back at like midnight, knowing that I had to go to work the next day. How do you deal with issues like that?
So you want to demonstrate to the court that this is a pattern. This isn't just one time they had a flat tire and they couldn't make it, right? This isn't just one time they had to stay late at work or something else like that. This is repeated, and it's intentional, and it's chipping away at the other parent's time. And so even if you're only 5 minutes late, but you're 5 minutes late at every single drop off, that all adds up. And it's also taking away at the trust for your child. So the child needs to be confident and needs to understand where they're going, when, who's picking them up, and what's going on. When you take that away and leave it all kind of up in the air, the court doesn't want, to see children go through that type of thing. So in cases like that, we're really trying to show that this is a pattern, that this is intentional, that it really isn't excusable. Or if there's been some other sort of change, maybe someone's work schedule has changed or something else like that is going on, well, then we need to go back and address it so that we don't have the same problem day after day or week after week. This is a material change in circumstances that the court is going to have to intervene and make a new order about.
And you reminded me of the 5 minutes late every time. I had a client, and the mother lived in Florida. He lived in Virginia. She was 8, 9, 10 hours late to exchanges. They were supposed to meet somewhere in South Carolina. And so when we talked about it, we were like, well, just send text messages to her, document things that have timestamps, document your location. So he actually figured out how to get on Google Maps and document where he was at what time and how long he was sitting there. And I will tell you that 8 and 9 hours, the judge was furious.
Yeah.
But my client was furious with me because he said, well, I'm going to be 9 hours late. I said, you can't be 9 hours late, man. You got to be perfect. And he said, why do I have to be perfect when she's doing this? I'm like, you have to be perfect. So when we go to court, you have to be perfect. So Dan, how do you talk to your clients who are being systematically cheated out of their time with their children, not to retaliate and say, look, you were an hour late, I'm going to be an hour late?
Right. And again, those are tough conversations because I get it. It's, yes, I want to do the same thing. If they can do that to me, I should be able to do that to them. And unfortunately, it's not an eye for an eye in these situations. And you were spot on. You have to be perfect because when I am presenting your case to the court, I want to just walk the judge through. These are the dates that the visitation is supposed to take place. This is where it was supposed to happen. This is where you showed up. This is the time that you showed up. This is the message from the other side saying, I'm going to be X minutes, hours late, or I'm not going to be able to make it, or I'm in a different location. Because as I walk the court through, we want the judge to see every time that visitation is supposed to take place for the exchange, you were there. And where was the other side? They're consistently late. And Rebecca was spot on because that could potentially be a material change. If you show that consistent pattern, that's a disruption to you, that's a disruption to the child, then you're missing out on potential time, and it's just changing schedules. And we're unlicensed that could potentially have a severe effect on the outcome of the case if you're in there for a modification, because you could change from a joint legal situation to a sole legal because the parents cannot agree on something. And if you can't co-parent together, then where I'm licensed at, the judge has to make a decision to go, if it's a joint arrangement, to a sole and award one party sole legal. There is one state where I'm licensed where the court can bifurcate some responsibilities. So in Illinois, they can say, okay, well, dad, you get these responsibilities, mom, you get these responsibilities. So it is still co-parenting, but we're splitting some of the responsibilities. But at the end of the day, that legal parenting portion of it with those responsibilities could be impacted. And you just want to continue to document. Unfortunately, it all comes down to documenting. And as frustrating as it can be, the more documentation you have and the more that you can show to the court that you're not being vindictive, that you're taking the high road, that you're looking out for the best interest of the child, that's going to go a long way. Because the minute that you go and have the same adverse or the same actions as the other side, it's just going to discredit you. And then the court is going to fall on deaf ears. And the remedy that you're seeking and all this time that has been spent trying to build up your case is going to be for naught, because the court's going to look at it, well, you're now doing the exact same thing that the other side did. You step down to their level. And so I don't really find merit in your case.
It's tough. I mean, we all feel cheated when somebody is getting to get away with something that we can't do. And, the culmination of the particular case I'm talking about, dad got 100% sole legal, sole physical custody. Mom has no visitation rights until dad says it's okay. And now she has to come and stay in a hotel room and gets visitation during the day only, no overnights. I mean, that was the judge suggesting to my client, do not give her overnights. And so it was a long road, but ultimately one where he had to come out victorious. So, Rebecca, How do you handle cases? So a lot of the cases that we have, especially during long breaks, start involving parents, right? So the not parents, the grandparents. So like parents are going to work back and forth. The grandparents are starting to get involved. What about when a third party is making visitation difficult, but it's a very close third party, like a grandparent?
Right. Then there can be, I mean, that's a pretty easy decision to say we're not going to let grandparent have custodial time anymore if they had some sort of visitation, or we're not going to let grandparent be the supervisor if they're the ones supervising the visitation or they're providing the daycare, whatever it is. If they're interfering, they're going to be quick to get cut out because grandparents and other non-related parties don't have the same rights to the children. And so the court is very quick to intervene in those types of situations, although it can be beneficial. If you want to have a neutral third party that's helping with pickup and drop off, especially if there's been violence or something like that, sometimes it makes sense. But if you have someone who's now further hindering the visitation, getting in the way, being late, withholding children, doing something like that, the court's going to be really quick to intervene and say, "Nope, sorry, this is an issue between parents and it needs to stay that way. Sorry, grandparents, but you're going to be out of the picture."
And that's a weird filing because I mean, your modification is you're trying to modify the other side's ability to make a decision while the children are with them. So you're
Right.
saying it's not the other parent doing the wrong directly, it's who the other parent is deciding to use for childcare. And unfortunately, in the jurisdictions I'm licensed in, grandparents' rights are somewhat, and extended family rights in general, are somewhat limited. Dan, how do you handle those situations where, like Rebecca said, it may be positive for the child, but it is causing a huge rift in the co parenting ability of the parties?
The lawyer answer, it depends. And I'll answer it on both sides. So if I have the client to where the in-laws or the ex-in-laws are kind of the disruptors, I advise the client reach out to the other parent, identify what the issue is, identify what your concerns are, and see if we can't repair that and fix it. It hopefully is an easy fix because hopefully, given the other side the benefit of the doubt, they're not involved in that. They're not encouraging their parents or their relatives or whoever that a third party is to be the disruptor. If it doesn't change, then it's just continuing to document, and then we may need to come in and file a motion with the court to modify. If I'm on the other side and my client's parents are being the disruptors, then I'll have a real frank, direct discussion into saying, listen, this has to stop. If not, then it could hurt what the current arrangement is in the sense that there may be some change and you may not be encouraging it, but the fact that it's still continuing to happen and you're now aware of it, then you could be, the court could look at that you're encouraging this or that you're supporting it. And a lot of times I like to explain, silence is acquiescence in the law. You may say nothing and you may disagree, but your actions will speak louder sometimes. So you want to just head it straight off the path and identify what the issue is, what can be done to address it. But if not, then in those situations, getting judicial intervention a lot of times will help because the judges will send the parties to mediation. You can hopefully resolve it there. If it's to where maybe there's the other side, grandparents or whomever the relatives are that are, or the third party is that's assisting, maybe they're talking bad about their side. So now we've got some type of alienation going on. So it is worth looking into. It's something I would never overlook because that's just the surface. And we really want to start digging down and what's going on. Why is this really happening? Usually the other side isn't aware of what's happening. And so they can shut it down fairly quickly. But there are unfortunately times to where the grandparents and the mom or the dad are in cahoots together and they're really trying to prevent the other side from having some type of relationship because whether the breakdown of the marriage is caused by some type of infidelity or violence or whatever the case may be, they're still hurt by it. And they think that attacking the other person this way is the best way to get back at them. And at the end of the day, I always advise clients, we have to think that the true victims in this, yes, you are one of them because you're subject to what's happening, but it's your child or children. They shouldn't have grandparents or friends or relatives speak bad about you or be late or just be disrespectful. We have to make sure that we're always holding ourselves to a higher standard. And And in those situations, we just have to, again, document, but at the same time, identify the issue, try to resolve it. And if not, in my opinion, those situations rise to a little bit higher to where we do need judicial intervention, because now we have a potential third party disruptor involved.
Yeah, I had a case one time, and what was tough about the case, it was a father who was a relatively nice guy, a mother who was relatively nice. I represent a mom, and it was the father's parents decided they were going to get him full custody, and it became really convenient for my client to use them for daycare and after school care, and they actually saw the benefit of it. My client was like, "But my daughter gets to go hang out with her grandparents." But then the grandparents started being like, "Oh, well, she wants to spend the night. Oh, she wants to spend the weekend." And so then we had to have a conversation about, look, you need to pay for your own childcare. So not only do you need to pay for me, now you need to pay for your own childcare. And she did, wisely enough. And as soon as she did, we saw the grandparents' true intentions come through, because they filed a third party motion trying to get all the time back, and we were able to defeat it. But the dad was, I mean, he just was like stuck in the middle. Like everything was being filed through him, and he just was stuck in the middle of all this. And my client enjoyed the free childcare, enjoyed the relationship they had, but did not enjoy that her child was trying to be stolen from her. And they were doing a very good job of it. I will give them that. So, Rebecca, when we talk about filing for modifications, and Dan and you both have touched on it a little bit, it's not going to be that you've had this problem today, you file tomorrow. I mean, what is a normal timeline in your jurisdictions?
Everything has to be kind of proportional, right?
Mhm.
You can have one big drastic event happen, and maybe that's enough grounds that we can go ahead and try and modify custody. Or it's this pattern of, not just that they've been late one time or 5 times or 6 times or something like that. It's every single day, and it's been several months. And they won't, let the child answer the phone, and they won't whatever, right? They're not participating the way they should. But it's been several months of this conduct that's just kind of right on that line. You really need all of it to add up together to be this magical material change in circumstances, is what the court is looking for. And so there's a whole laundry list of factors. It's just like looking at the best interest of the child, right? There's a whole bunch of different things that can be material changes. Some of the more common ones involve when there's a new spouse or a new relationship, and that can be a positive or a negative. You might be showing that we have this established, sort of new family that has, a lot more solidity to it or something like that. You might be trying to show that there's a negative with the new spouse, right? That can be a pro or a con. Someone might move, they might change jobs, they might change school districts. One of the factors is the child's age and their respective needs and their relationship with either parent. So sometimes we see children, once they get up into adolescence, they need a different parental figure at that point. So maybe a son who's been living primarily with mom, once they get up to be 13, 14 years old, they're starting to need more of that male influence in their life. They're starting to need more time with dad. So it's really a combination of all of these things. And you probably won't have every single factor in every single case, but you need to have a good handful of them. It can't just be one thing. And we actually just had a case come down in Virginia that said just the child's preference alone was not enough to be a material change in circumstances. The court needed to see some of this other stuff going on. What's going on with the school, with the after school activities, with the child's social circle, with the other extended family. Like, we need other pieces of this in order to put it all together and have it be this material change, not just a change. So those are some of the things that the court is looking for. Big obvious ones are like somebody's moving out of town. We're going to have to modify custody, right? That obviously is going to be a material change. But all of the other ones, you really have to combine them together and show how is this impacting the child specifically, not just what's the difference in the parent's life, but what's the difference for the child and how does it relate to custody?
Like you said, you have to put the whole thing together. And then the last thing you have to remember is, once you put all this together and you take it to the court, you're not going to get a resolution instantaneously. It's going to take time for the court to go through this process. So that's when it becomes most imperative, because now you've started the fight sort of with the court. The other side is probably going to not react nicely to you, and you still have to fight to be the perfect co-parent at that time. So Rebecca and Dan, I want to thank you for joining us this week. Next week, we're going to have a special guest to talk about back to school issues. And we look forward to hearing from you all. And if you know someone who's going through divorce or you're going through divorce, give them a call and see the difference to the partner.
Hi, this is Dan Cuneo with I Now Pronounce You Divorce. Thank you for taking time to listen to this week's podcast. Please join us next week for part 2.